Mr. Chair and members of the committee. For the record, State Representative Lauren Davis from the 32nd District. I first want to echo the chair's comments thanking Jim for his incredible and heroic work drafting this very complex bill. And I want to thank Ranking Member Mossbrucker from the bottom of my heart and Assistant Ranking Member Griffey for co-sponsoring this with me. In the summer of 2021, I ended a tumultuous 2-year relationship that was defined by a pattern of severe psychological abuse and coercive control. This wasn't the first time I had gotten away, but it was the last. When I'd broken up with him previously, my abuser would threaten my career or threaten to kill himself in order to get me back. The day I left for good, he used his body to block my exit so I couldn't leave his house. I was able to break free, and I never looked back. That's when the stalking began. Obsessive, repeated contact, calls from blocked numbers at all hours of the day and night, contacting my friends, using other people's phones to text me, leaving threatening voicemails. Over time, his messages became more desperate, more angry, more frightening. When his stalking didn't work to regain control over me, he started threatening me. And when his threats didn't work to regain control over me, he acted on his threats. There were numerous lethality factors present. My abuser had 3 prior convictions for domestic violence. He had relapsed and was using substances heavily. He was suicidal. He was stalking me. He was escalating rapidly, and he owned many firearms. My domestic violence victims advocate told me that I was at high risk for intimate partner homicide and unsafe to remain at home. So I packed up my things and I fled. I was living in a constant state of terror. Fear, I learned, destroys your body from the inside out. I could barely eat, and I dropped to 15 pounds. I was shaking all the time, and I was diagnosed with PTSD. All I wanted was for the abuse to stop. All I wanted was to go home. But I was so reluctant to seek a protection order. The records are public and permanent. More than anything, I was afraid that if I sought court protection, it would push my abuser over the edge. I feared he would carry out his prior threats of suicide and that he would take me with him. But my DV victim advocate said 2 things that changed my mind. She said, "Lauren, the only one benefiting from your silence is him." And she said, if he kills himself, it will be his last act of abuse to you. Something shifted in me then. I pivoted from victim to survivor. I was ready to fight for my life. And that's when I ran into my first roadblock. I couldn't find an attorney anywhere. There are so few attorneys who represent survivors of domestic violence. I filled out online forms. I left voicemails. Crickets. But I did discover, while scouring Google, that abusers' attorneys abound. They have 24/7 hotlines to call. The only reason I found any attorney at all was because I knew someone who knew someone. Because of our modest wages, I qualified for low bono legal services. Even then, my attorney's fees ended up totaling $25,000. Nearly half of my annual legislative salary was spent petitioning a court for the right to not be murdered. My situation felt like an emergency to me, but apparently not to anyone else. The first date my attorney could go to court for an ex parte order was November 10th, 2021. But that came with a risk, she cautioned. The next day was Veterans Day. It was possible the order would not be transmitted to law enforcement until the 12th, and this could have allowed my abuser to learn of the order's existence and hide his firearms. I proceeded anyways. Waiting was not an option. Law enforcement, the court granted an emergency domestic violence protection order and order to surrender weapons. Law enforcement served my abuser with the order and confiscated 17 firearms. Protection orders are not enforceable until they are served. I was not properly informed that the order had even been served until a week later when my abuser filed his notice of appearance in court. In January of 2022, the morning of the final hearing on the protection order, my abuser attempted suicide and nearly died. He wrote a note blaming me for his death, and sent the suicide note to his DV defense attorney. Research indicates that an abuser's suicidality is as predictive of intimate partner homicide as strangulation, assault, and threats to kill the victim. James Baldwin once said, "The most dangerous creation of any society is the man who has nothing to lose." 1/3 of all intimate partner homicides are murder-suicides. The case kept getting continued due to my abuser's long hospitalization. At one of the continuance hearings, a pro tem commissioner told both me and another victim that our protection orders were force fields that would protect us from our abusers. This was a curious statement from a judicial officer. Research indicates that up to 60% of DV protection orders are violated. There are 9,000 no-contact order violations in Washington state every year, and 1 in 4 women who are murdered have an active protection order in place. The day of the final hearing came in March of last year, 1 week after Sine Die. A pro tem commissioner denied the full protection order, ruling that I failed to prove that my abuser intended to injure me. In a stalking case, the petitioner must meet the evidentiary burden for 3 elements of the crime. Proving the stalker's intent to injure is not one of them. The commissioner made a clear error of law, an error with potentially fatal consequences. I immediately requested a revision for a real judge to hear the case, but the next court date was 6 weeks out. The very day the order was denied, my abuser contacted the police seeking to collect his firearms. I invoked Sheena Henderson's law, which initiated a 72-hour delay in the return of his weapons. Then I started researching the criteria for extreme risk protection orders. I petitioned the court for an ERPO, and it was granted without hesitation. I had to piece together such a complex patchwork of statutes to prevent my abuser from accessing his firearms and save my own life. The day of the revision arrived in May of 2022. The judge not only ruled that my abuser had stalked me, but that the lethality risk was so exceptional that it warranted a 5-year DV protection order coupled with electronic monitoring. State statute has allowed electronic monitoring in protection order proceedings since 1992, the year I started kindergarten, but it was rarely, if ever, used. Electronic monitoring with victim notification not only saved my life, but it gave me my life back. In June of last year, after 217 days in hiding and 14 different safe houses, I finally got to go home. I will never forget that day. Fake cobwebs with plastic spiders still clung to my door, and a pumpkin-clad tub of candy sat in the entryway. The day I had fled was the day after Halloween. When I was a little girl, one of my favorite books was Goodnight Moon. The text reads, "Goodnight bears, goodnight chairs, goodnight kittens, and goodnight mittens." As I walked around my house that early summer day, I found myself saying aloud familiar words. Hello, lamp. Hello, bed. Hello, chair. I couldn't believe I was actually home. After that, life began to return to normal, or at least my new normal. I was able to sleep again. The nightmares about my abuser slowly began to fade away. My therapist even noted that some of my PTSD symptoms, like anxiety and hypervigilance, had begun to remit. For instance, I stopped having a full-body panic reaction anytime I saw a car similar to my abuser's. If the proximity alarm on my phone was not going off, I knew it wasn't him. A month later, my abuser violated the protection order and was taken into custody. The evening of his arrest, I received a tamper alert on my victim app indicating that his ankle monitor, my safety lifeline, had been removed. I was startled by this, but I assured myself that the jail must have taken it off upon booking. The following afternoon, the jail released my abuser, but they failed to reattach his ankle monitor. I became physically ill. I couldn't think. I couldn't speak. Hot tears streamed down my cheeks as I raced around my house, throwing clothes in a paper grocery bag and running out the door. There I was, fleeing for my life once more. It was but one more abysmal system failure. I am a white, educated, English-speaking woman. I have every privilege in the world, and yet our system failed me over and over again. I've spent the last 18 months careening through every part of our state's domestic violence system, and I am here to report that it is horribly broken. I may be a victim, but I'm also a lawmaker. And so at each and every twist and turn, every time something went terribly wrong, I wrote it down. I promised myself that if I lived, I would change things for other survivors. The bill before you today systematically closes every hole in our system that I fell squarely through. It addresses every gap, every choke point that I just described. It empowers victims by providing them choice and safety. It offers new tools to hold perpetrators and our system accountable. It implements national best practices for the prevention of DV homicide. It makes addressing domestic violence a Washington state priority. This bill builds the safety net that I wish had been there to catch me, and I humbly ask for your support. Thank you.